Okay, we are back on the record. We're here in the matter of Valleys Planning Council, Inc. and Peter Fenwick, trustee of the Charles C. Fenwick Residential Marital Trust. They are the petitioners, and respondents are 3366 Belmont Road LLC, 3500 Belmont Road LLC. And it's case number 25-029-SPH. We recently conducted argument on the motions filed by council. And we adjourned for public deliberation, and we adjourned for lunch to come back for the public deliberation at 2 o'clock, which is today, which is now, and we will now hold the public deliberation. So I guess first of all, we don't have to do, we already handled the Pro Hoc Vice issue, correct? So now we deal with the motion to dismiss and the motion to quash. I guess we could do motion to dismiss first. So does anybody have, I mean, this is a tough, very tough case. I mean, I haven't been on the board for 5+ years, but I've never seen had any scenarios quite like this. So there's a lot of intertwining issues here in the motion. Does anybody want to start?
Michael, do you want to start?
Yes, sir. Please go ahead.
Okay. I'm sure the board has reviewed your motions and the files, etc. I would move to grant the motion to dismiss. I think there are several things I jotted down here. I think there's vagueness in the petition itself. The question asked is whether it may be used for weddings, etc. My answer to that, and I know we'd have to get to the case in Maine, but is sometimes, depending on the condition, seems a little vague. And second part of that is whether it be used for weddings, whether the use of this for weddings constitutes a catering hall. And I think the answer again is maybe kind of if we know in general that it can't be used in an RC2 zoning district as a catering hall. That's pretty clear. But maybe if, okay. I don't know, in terms of looking at the code and the definition of catering hall, if 21 times in 12 years is regular or not. I don't know, and maybe the case would have figured that out. But I think there's vagueness in the question presented. That's one thing I would say. I think the case is distinguishable from other cases that were cited. There was no prior matter before the board or the ALJ. I think in terms of looking at 500.6 and 7, I don't think this falls under those provisions in terms of what is the criteria are basically for a special hearing. I believe that another form of relief is prescribed in the code, and that's code enforcement. Filing with the code enforcement seems to be an appropriate thing. I don't think, though, as was argued, that it's a prerequisite, I can say that, for filing. Either file it or not file it. But I do think that code enforcement would be better able to investigate and handle the questions as kind of presented and alluded to here, rather than this board offering its opinion on those. So I think code enforcement may be a better vehicle. I'm not clear from the filings what the claims are and the rights and status related to those claims for the filings of the special hearing. Still not clear, and I think there's some vagueness and questions regarding the remedies, Mr. Chairman, and how we would remedy this, other than by saying, yeah, if you have a catering house in a R2 zoning district, it's a violation. Okay, all right, we got that going for us, you know? How do we clarify that, go back through all events, make a determination of each one of those? I'm not so sure then that we go further in terms of the remedies or relief and are able to put a reasonable opinion together that clarifies for all parties what our position is. And finally, and just in general, it appears to me that we're asked to offer an advisory opinion. In terms of that we're kind of guessing, interpreting, applying the law, somewhat a hypothetical case, somewhat a speculative manner. I don't think this is the role of our board to do this. Therefore, I grant the motion to dismiss. Those are the things I've got now.
Thank you, Mr. Lauer. Yeah, any thoughts?
I mean, first to Mr. Lauer's point about code enforcement, I think I agree with Mr. McCann that I think it's unlikely that code enforcement is going to do anything about the events that are taking place here if they are a violation of code. But I don't know that within what we have been asked to determine that we can grant the relief here, no matter what facts were to come before us in a hearing. I think that whether the subject properties may be used for the hostings of weddings, parties, fundraisers, celebrations, or other events, the answer to that specific question is maybe, as we've discussed during the hearing itself. And that maybe is based on the criteria of those events, but I am not convinced that having us hear about particular events in the past, I'm uncomfortable with hearing details, facts about past events, and then saying, well, then in the future, these are going to be the events that happen in the future, because I don't know that those are going to be the future events. And I don't know that we can take those past events and then nail down some criteria to judge them that we can put in an order that says, okay, you're allowed to do this. Okay, you're not allowed to do this within the world of possible future events. I just don't see how that's possible. And I also think it's very different from what was asked of the board in some of the other cases that were brought to our attention during the hearing. Those were interpreting previous orders, or things that had a very specific criteria. Is this I'm sorry, I don't have it in front of me, but like, was this a brewery event within, this particular code? This is what we're being asked here is very broad. And I'm uncomfortable with just giving an answer, which is, yeah, okay, sometimes it is, sometimes it's not, it depends. Come back to us later. Obviously, you can't come back to us later. And I don't know that it makes sense to have a hearing for that purpose. So the issue of is it a catering hall? I mean, it's possible that we could have a hearing to make that determination, but just based on the question that's being asked here, the definition of catering hall is a thing that happens with regularity, that advertises itself as a catering hall. And like, yes, maybe there might be some testimony as to that, whether that's true or not, but I don't think, just based on what was proffered to us so far and what was in the hearing below as what there was, I don't think there's going to be any evidence out there that shows that this, even if you take these events that are going to be proven to us as all being the case. You know, I think a catering hall is a thing like a Martin's West that advertises itself every day and you go to for an event specifically. And I don't think that's what is happening here. Now, if you guys were like, yes, I want to have a hearing just on the issue of the catering hall, maybe, but again, within the definition of what's allowed in the RC2 zone, I mean, I think I agree with the reasoning from the ALJ. He discusses it at length, and I think his reasoning is sound.
Okay, you would grant,
Yeah.
grant the motion. Okay. I agree with both of you. I would grant it as well. I mean, I'm not, and just make sure that I am not basing any of my decision on whether or not the petitioner followed court judicial proceedings 3-401. I don't know. I don't think they need to adhere to that for a special hearing. But as far as the 500.7, I mean, I think 500.7 specifically states that there must be it says the existence of a purported non-conforming use. I mean, if something that happened in the past that's one thing. I don't see to me, it needs to be a current non-conforming use. And that's what it looks like all the other cases were. They were non-conforming uses that were correct. I mean, they were ongoing
It's an
non-conforming uses.
ongoing, not a event-based thing.
Right.
It's a thing that's there every day.
Right. So I agree that with Mr. Lauer that I think code enforcement I agree with both of you, but I think code enforcement should be the way to go in this. And I don't want to reiterate everything you said. I agree with what both of you said. But I just going back to when you're hearing a motion to dismiss, what do? We have to assume that the truth of everything in the petition. We have to view it in light most favorable to the petitioner in this case. And then dismissal would only be proper if, if all those facts and allegations, inferences, if they were all assumed they were all proven. And if they were proven, then to me, they still fail to afford any relief. And that's the whole law on motions to dismiss. You prove your case. I think you could prove your case, everything you said, but even when you prove it, I don't think that there's a remedy. So, and I think both of you said that. So that's where I agree.
Yeah, I mean, that's ancillary. I'll just go back real quick to the issue of the declaratory judgment. I think within what we're looking at here, we don't necessarily there doesn't need to be like an active dispute to ask for our relief under a special. I think that is kind of off in left field, is really not determinative of what we're talking about here, but I think it got brought up, and I don't think someone needs to have, like I said, there doesn't need to be two parties for a hearing of this nature. All the time that people ask for some sort of relief from us concerning the use of their property in a special hearing, and it's just them. They can do that. So I think a third party could do that too, but obviously you're dragging someone else in for. I don't think there's anything wrong with that. I just think, notwithstanding the rest of the opinion.
Okay. Anything?
No, nothing
Okay.
further.
With that, I guess we'll go off the record. Right?
Well, there's a second part. I don't know if we need to get to it though.
Oh, the subpoenas, right? Okay,
I don't
well,
think we
I
need
can
to
tell
get
you,
to it.
if we did get to it, if we want to do it for good housekeeping, I would certainly dismiss the motion to quash the subpoenas. I think what Mr. McCann was asking for was relevant and reasonably calculated to the discovery of admissible information. So I would have allowed the subpoena.
I would not.
Okay.
I think they're too broad. But I don't know that we even get there.
We don't, but still, I mean, I don't think they were too broad. Dealt with subpoenas a lot in the past.
And proprietary, I would agree. This point that was also made.
Okay.
We're not going to If we're not gonna
Okay.
make a ruling on it, I'll just reserve my
I'm
judgment.
not gonna weigh in.
Is there anything else?
I have nothing else.
All right, thank you all, gentlemen. And I'll stop recording now.